Hello, everyone. Thank you for joining us for our Chatting with Charlie, where we'll go over the February 2024 Visa Bulletin. We go to the next slide. Just a legal disclaimer, this does not constitute legal advice. Please reach out to us and schedule consultation with one of our attorneys. And just a little bit about WR Immigration. We are based in Santa Monica, but we have offices globally, 9 offices, plus 150 professionals. We would invite you to check out our technology solutions that we've provided to HR professionals and global mobility programs called Rapid. And I'm Charina Garcia. I'm the Strategy and Innovation Partner for WR Immigration. I am joined again with Charlie Oppenheim, who leads our government relations group. He was the chief of State Department's Visa Control Unit for 23 years, where he directed all numerically controlled immigrant visas. And I'm also joined with Laura, and she's our senior associate who will discuss issues that are on the top of mind of many of our global mobility managers. Thank you, Laura and Charlie, for joining.
Happy to be here again.
Same here.
All right, let's get this rolling. So big news, big update. We're moving to another platform. So starting in February, Chatting with Charlie is going to transition from Zoom to LinkedIn Live. You will still receive the registration links via email for easy access. We're also going to be introducing the Bulletin with Charlie Oppenheim, a podcast as well. So you can enjoy weekly episodes featuring live Chatting with Charlie events. We're also going to have in-depth discussions about the Visa Bulletin. We're going to include conversations with industry and policy experts, and we will be expanding our Q&As for listeners and much, much more. So stay tuned. You can also find all our episodes on YouTube, Spotify, Apple Podcasts, and any other popular podcast platforms. So we ask that you stay connected, follow us on LinkedIn and YouTube to get the latest updates and information. And then one important date, the Chatting with Charlie EB5 Investor Webinar scheduled for January 30th will be its final installment hosted on Zoom. Again, this will be our final installment hosted on Zoom, and we're going to move to LinkedIn Live and then also some podcasts. So we're really excited about these changes. So with that, we're going to have some discussions. We have a lot of questions about what's the difference between Chart A and Chart B, so the final action chart and the dates for filing. We're going to go through the summary of the February Visa Bulletin and what are the trends. What are Charlie's predictions for March for employment-based and family-sponsored? We're also going to talk about the increase in USCIS filing fees, the new pilot program introduced by Department of State for the H-1B domestic visa renewals. We also welcome you to put questions in the Q&A, and we'll see if we can answer them today. If not, we'll answer them at the next session. And with that, let's move to understanding Chart A and B. So Charlie, can you give us some information on what's the difference between Chart A and Chart B?
Sure. The Chart A is the final action dates, and they indicate which applicants can actually be scheduled for an interview or have their adjustment of status case finalized during that particular month. And it's based on the best information which the State Department has at the time of their setting those dates. One thing it's important to remember is that not all applicants with a priority date earlier than the final action date have actually been processed, so that there can be sometimes changes from month to month. The Chart B is where the State Department, in conjunction with or in consultation with the USCIS, believes the final action date listed in Chart A will be in approximately 8 to 12 months. And the goal of Chart B is to allow applicants to begin submitting certain required documentation and for the case to start being processed so that when the applicant's priority date is reached in the 8 to 12 month time period, it can be finalized in that particular month instead of making the applicant wait until that time to actually submit anything.
So I remember when I first started my career back in the late 90s, there was no Chart A or Chart B.
Correct. It was a change was made, I believe, in October of fiscal 2015 at the request of the Immigration Service they decided it was in their interest and the best interest of applicants and to increase visibility of demand if they were to start using the same type of dates that the State Department had been using. Prior to that time, the State Department used what was called qualifying dates, and the term changed to the application filing dates. State would go out and tell applicants to start assembling documents so they'd be reviewed at the National Visa Center and then reported. Once the case became documentarily complete, it would be reported to the visa office. So it provided a great visibility into demand and lessened the volatility and movement of the family-sponsored final action dates. And so immigration wanted to adopt that same policy beginning at that year. The Immigration Service only allows Chart B to be used for a specific amount of time. They are allowing it to be used for February. They've already announced that. I would not be surprised if they end the use of it in March or definitely by April. So people should take advantage of filing based on Chart B in a timely manner.
And based on that, if we go to the next slide, can you explain to us the Chart B and the filing date projections?
Right. And as I said, and I kind of jumped the gun a little bit, but they're trying to generate demand. So, and let the case begin to be worked on, because it typically from the time an applicant files the case, say with the Immigration Service or with State Department, it takes maybe 3 to 5 months maybe before all the required information has been reported and been processed. So this allows both agencies to get a jump on processing so the case can be acted on later on. And again, with these filing dates allow to maximize number use in each particular visa category by the end of the year and avoids any wastage of visa numbers.
Okay, and so if we look at the Chart B dynamics in our next slide, what could you share with that and the interplay with the USCIS?
This Immigration Service does at least 85% or uses at least 85% of the visa numbers in the employment categories. So the State Department relies heavily on their statistical data that the USCIS can provide in the determination of the Chart B dates. And then with Chart B on the family-sponsored numbers, the State Department does at least 95% of the processing of family cases. So they get information from the National Visa Center and the Overseas Post. So we do it that way. But again, it was in the past, several years ago, I believe in October of fiscal 2020, I'll give you an example. The India third preference application filing date was extended extremely far out. And then the amount of filings that were beginning to occur exceeded the amount expected by the Immigration Service by tens of thousands. And it resulted in the Immigration Service requesting that India third preference final or application filing date be retrogressed by approximately 1 year. And again, they had not expected the huge amount of filings that they received.
Well, when you're determining whether to use Chart A or Chart B is universal for employment-based and then also for family-based. So for example, they could say that you could use dates for filing for family-sponsored, but you can't use dates for filing for employment-based. Is that right?
They could. And the State Department uses those dates continually. Once the Chart A or Chart B dates are announced, the State Department will apply those continually, whereas the USCIS may at some point indicate that the Chart B dates will no longer be used for advanced filing.
Great. And then Laura, how does this actually interplay in your real world and how you advise clients?
Yeah, I mean, I think having Charlie's tutelage, it definitely allows us to predict for, budgetary purposes for our clients, like when we expect cases to advance to the adjustment of status. stage, which incurs different filing fees. It also allows us to predict, when we're initiating a green card case, just how long the life cycle is going to be before someone is eligible to file. So having a good understanding of how Chart B allows the filing, or in some instances in the cycle of the fiscal year does not allow the filing, we are able to talk through our clients to set expectations. As Charlie was mentioning, we want our clients to file as soon as they're eligible under the dates for filing. So preparing our clients, educating them on what documents they need to have, and getting that notice ahead of time so they're ready to partner with our team to file as soon as possible.
Yeah, and with our data, we can actually benchmark and actually see if the USCIS is actually adjudicating those cases in 8 to 12 months from the date of filing. It'll be interesting to see that for our next podcast, whether that actually holds true and how far off they are from the 8 to 12 months. But we'll check that out next time. So let's talk about the February Visa Bulletin, Charlie. This is the dates for filing chart, and you mentioned these dates for filing are being held for Chart B.
Yes. And I would expect that the employment dates to probably hold because unless they see that the amount of petitions actually being filed drops below their expectation. But I would not be surprised if these were held at least until the summer. They may advance them at some point in the summer months in order to start generating demand for fiscal 2025. Or if they are seeing that their previous projections were not producing sufficient amount of demand.
But do you think the USCIS will use dates for filing for the coming months too, or we're going to see?
I think there is, based on, past performance, I think there's an excellent chance that they could stop using them effective March or definitely April. So I think it's important to file now and during February, where they've already announced that they will be used, and then be pleasantly surprised if they continue to allow them to be used in March. But you should never take anything for granted. Typically, in past years, it's been between January and March that they've announced that they will no longer allow them to be used for early filing.
And Laura, this impacts our clients, right? Because if they have international travels, we can't file their adjustment unless they're here.
Correct. Must be in the United States to file your adjustment of status application. We do have a relevant question from the chat line, and I think it's a good chance to clarify. After someone is filed based on Chart B, is it possible to get an approval and final action before their final action date is current? And that answer is no. Their date has to be current. Their priority date has to be current under final action in order to receive an approval. So as Charlie was mentioning, Chart B allows the filing and in theory allows the service to review the file, do all the checks, go through the information, so that in 8 to 12 months, when the priority date becomes current for final action, they're able to immediately move on that case. So USCIS cannot issue an approval until the priority date for that individual becomes current for final action.
Thanks for clarifying that, Laura. So we can go to the next slide, and this is the final action trend, and this is for all chargeability or rest of world. So we see a bit of movement in EB2 by a couple weeks, and then we see a movement of a month in EB3. So Charlie, any comments on this?
No, I think this is a positive sign, and that we could, a later slide will show our predictions, but I think that we may be lucky and see some slow forward movement in the rest of world employment second and third preference dates in the coming months.
Okay, and for China?
China, everything is held. And I mentioned in December when the January dates were announced, you'll notice that the January dates advanced significantly from those that were in effect for December. And at that point, I mentioned that it is possible that the State Department is advancing the dates at the beginning of each quarter in an effort to allow a sufficient number for the entire quarter to be used. For example, the dates that were announced in October were a significant jump from where they were in September. Then they pretty much held. There was some slight movement in December, but then there was another big jump in January, the beginning of the second quarter. So by doing so, this would allow state to get more visibility if their predictions number use were correct. And if then they were to see that there was not as much demand as they expected, they could continue, then move later in the quarter. They could advance the date at that point.
Okay, we have a lot of questions about that, so I'm sure we'll address it again later about China and the lack of movement in February, but we can move on to India.
For India, there was a little bit of movement in the third preference. That was the only category that advanced. I would not expect similar movement in the coming months for India third. I think that this was kind of a way to, as I said, to jumpstart the processing of cases and see if their estimates of number use in the India third preference based on that July 1st date is going to be accurate, or, if they may need to take some other type of action. They could advance it a little bit, but I would not hold out much hope.
Okay.
At least on a regular basis. I think they will advance it throughout the remainder of the year, just not very much, and maybe none at all in most months.
Okay, so that's kind of like a recap. If we go to the next slide of your predictions. So you want to run through EB1, EB2, EB3?
Yeah, these are the movements I would expect on an average. So it may not move, say, for the India third. I've indicated that no movement up to 1 week. It may not move for 2 or 3 months, and then may advance by 1 or 2 weeks. So these are averages between now and September on what the date movement will be. One of the things with the India in particular, and also in China, is there is so much pending demand based on earlier filings from in fiscal 2023. They have a huge amount of demand that they can tap into, so they can kind of take their time and wait until the summer months when they see, we've built up a big supply of numbers, and now we see that they're not going to be required, so we can advance the final action dates and maybe wait to do so in the summer, knowing that when they do advance them, they're going to be able to use all those numbers and reach the annual limits. The one positive thing is that if there are unused family-sponsored numbers under that annual limit for a particular country, they can fall down and be added to the numbers available for that country in the employment categories. And based on what I've seen in terms of China family-sponsored number use in October and in November, I think there is an excellent chance that potentially thousands of numbers of unused China family numbers may fall down and allow the China dates to move at a faster pace at some point.
How fast do you think, Charlie? Like, you're predicting 5 or 6 weeks?
I think it could be, a 25 or 50% increase in the movement, because it all depends on how many numbers are likely to fall down. But like I said, the number use totals for October and November are extremely low in comparison to the amount which could have been used in those particular months. That doesn't guarantee that rate would continue. So we'll just kind of monitor that. In India, historically, India has used the vast majority of India family-sponsored numbers. Maybe in some years 1,000 to maybe a maximum of 2,000 might fall down. But that I would not count on that for India. Whereas China, I think there is going to be a lot of numbers allowing the China dates to move more than what I'm saying here.
Oh, good. So we'll have to just wait and see, and hopefully we have some good news for China folks. So we can go to the next slide. And this is about our family-sponsored dates for filing. Again, no movement from the October dates. And so, Charlie, any comments on that?
No, the State Department, as I said, has much more visibility in the demand because for years they've used the application filing dates, and they have a very good handle on how many numbers are out there and how many can be used. So I would not be surprised if these dates were held. Again, they may start advancing them in the summer months so that they can generate family-sponsored demand if they feel it's necessary for processing in fiscal 2025.
Okay. And then we go to the next slide, which is our final action dates. So a little bit of movement in F2A. Any comments on this?
The F2A, I think that could continue or will continue to advance. For one reason is the final action date for 2A was current from about July of 2019 and for an extended period. So most of these cases with, applicants with dates earlier than February of 2020 potentially could have been processed long ago. So I wouldn't be surprised if the 2A category continues to advance. And I would expect some future advancement of the final action dates for the other family, at least rest of world, all chargeabilities, to start advancing some in the coming months.
Okay.
And it's important to remember that China follows all of the family-sponsored F1 through F4 dates, and India uses the F1 through F3 dates. So,
okay. And Laura, let's talk about the news about the increased premium processing filing fees. So what can you share about that?
Yeah, so premium processing fees are going up effective February 26th. So that will start to hit companies' bottom lines, especially for those H-1B transfers that almost always are premium processed. And for any max out cases, those Form I-140s are also requiring premium processing, and those fees are going up. So you'll notice the difference that your premium processing from $2,500 to $2,805, so a $305 increase. So I know for our clients, we are reviewing whether all petitions require premium processing, which ones we recommend premium processing. Again, for the H-1B transfers, strongly recommend premium processing, but for timely filed extensions, there's not a need unless there's a business need to travel. So walking through those conversations with our clients to ensure clients are making cost-effective, cost-efficient decisions for their business. Of course, the foreign national employee can pay for premium processing. So if there's a personal need for the employee to travel for a wedding or family obligations out of country, the foreign national can pay the premium processing fee for any of the petitions.
Okay. And then if we go to the next proposed filing fee increase, when you say may arrive soon, what are you thinking soon is?
We're thinking spring or summer. So yeah, more increases. And this is across the board for many employment-based petitions by significant increases. So we're having these conversations now with our clients, in addition to projecting budgets with increased premium processing fees. We're also projecting out what increased filing fees look like for our clients for the rest of 2024. And again, to Charina's question, we're estimating those fee increases to hit as early as the spring or summer of this year. And to put it into a historical context, these fee increases were initially discussed in 2016. So this isn't a surprise that USCIS is interested in increasing the fees. It's a conversation they're now revisiting under the auspices of increased fees will allow the government, or the USCIS rather, to hire more staff to perform and service their clients better.
Yeah, I think the last fee increase was about 8 years ago. And they introduced this about a year ago, these actual numbers. But you're saying for this upcoming H-1B registration period, it's still going to be $10, right? It's not going to be the 205.
Right. Yeah, we're not expecting it to impact this year's registration, but your H-1B transfers this summer. That could definitely be part of how you're impacted, how your company is impacted with these significantly increased fees. So definitely reach out. We're happy to project. I love doing the budget forecasts, predictive forecasts that we use our platform to provide you those insights so that your teams can plan accordingly. Your managers understand what's hitting their budgets and when.
Yeah, I mean, just look at that L1. It's going up from 460 to 1385. That's a pretty big jump, right? And then our H-1Bs are going up by 70%. So that's going to be a huge impact on the budget and planning.
Huge impact, exactly.
And then the next slide. So there's this Department of State pilot program. So can you give us some more information about the domestic visa renewal process?
Yeah, so this is really exciting news that certain H-1B folks will be able to renew their H-1B visas by staying in the U.S. So this pilot program won't accept everybody. So I know a lot of people are excited. And we expect that there'll be more people applying for the visa renewals than the pilot program will allow. But you have to meet certain criteria, like if you already have a visa that's been issued by Mission Canada or Mission India, you can apply through this pilot program. You pay the fee, you complete the DS-160, and if you're accepted, it may take 6 to 8 weeks for you to receive your visa stamp by staying in the U.S. Through the stateside visa renewal program. So it's really exciting. And, I'd love to see them expand the program to more or all H-1B visa renewals and then other classifications like E's and L's.
Yeah, when I first started practicing way back when in the late 90s as well, they pretty much all visa types we could do visa revalidation. So I'll have to see. Time will tell if we can do this, but this would be a vast improvement and help a lot of clients in their travel planning.
Yeah, 100%. I actually just talked to a client that's very interested in this because the nature of their work, they have to be on site for quality control. So, going for a trip outside the U.S., they just can't be outside the U.S. with enough PTO to complete visa stamping at a consulate in India. So this is a game changer for many people, and then especially this one client that truly can't take that much time off.
Yeah, this would be wonderful. So we'll move on to our questions. So Laura, if I-140 and I-485 can be filed concurrently, I-140 being the shorter of the two, why is premium processing ever needed?
So this is a great question. So the I-140 has to be approved in order for USCIS to approve your I-485. So in situations where your I-485 or your priority date rather is current for final action, we would recommend that you premium process the I-140 because you want to have that I-140 approved very quickly so the I-485 can be processed. I'll give you an example. We had a client who was a Chinese national EB2 with a priority date in 2017. The reason he didn't file earlier is because they changed jobs. The new company had a 1-year tenure, and it takes about a year to get a perm certified. So that's all to say that we filed concurrently I-140 with premium processing and I-485 in September of this year. And his I-485 then was approved in 4 months. It was key to file that I-140 with premium processing so that the government could quickly adjudicate the I-485. So if we had not premium processed the I-140 could still be pending. And therefore, the I-485 is still pending and no green card issued.
But it's not a guarantee that if you premium process the I-140, the I-485 will be premium processed as well.
No, not a guarantee, but it certainly tees up the ability for the government. And so in a case where this guy has a very favorable prior date of 2017, we don't want his case, his green card, to be held up because the I-140 is still pending.
Yeah. And then Charlie, share your movement of dates in future for India and China-born applicants. You went through it in your chart. Do you want to just kind of recap it for the?
Yeah, I think we reviewed it there, but I think one thing it's important for listeners to remember that as long as there are rest of world employment second and third final action dates, that means that any movement of the India and China final action dates will be based on the amount of visas available under their per country limit. This year's limit in the second and third preference for India and China will be approximately 3,223. So that is a very small amount of numbers given the large amount of potential applicants, and will have a dramatic impact on any movement. In earlier years, especially in the India second preference, they were the beneficiaries of large amounts of otherwise unused rest of world numbers, because the rest of world second and third were listed as current. Any unused numbers under the worldwide limit could be passed to those countries with the earliest priority dates applicants.
So Charlie,
Again.
Yeah, go ahead.
No, go ahead.
Just a quick question. So you had said that there are going to be unused family-based, possibly for China, right? And so how does that impact that 3,223 per country limit that you were mentioning?
Well, say that there is just to make it easy, say there's 1,000 unused China family numbers. Then that 1,000 would be divided amongst each of the employment categories. So the employment first, second, and third preference would get 28.6% of those numbers. So China would get an extra 286 numbers added to that. So they'd go from 3,200 to 3,500. And the same potentially with India if there were unused numbers. But you can see how that redistribution of unused family numbers, if there were thousands of China unused numbers, that could really positively impact China movement in the future months.
But do we know why there's going to be some unused family-based numbers? Any guessing?
No. Sometimes the State Department will announce in the Visa Bulletin if there's issues impacting processing. I haven't seen anything. When I was chief, it was always during the Chinese New Year's you could expect China number use to be a little bit lower. But again, when I look at the number use totals that the State Department is publishing, they were family-sponsored numbers for China are extremely low for October and November.
Okay. We'll have to wait and see, like you said. Did COVID and NIW, which is National Interest Waiver Premium Processing, contribute to EB2 rest of world retrogression, or simply more NIW applicants? Will it be current soon? So, Laura, any comment on that? And Charlie, you can follow up on that too.
So certainly here at WR Immigration, we've filed up to, I think, 400% more complex writing cases. So that includes the NIW applications, EB1. So certainly there are more folks filing in that category for a number of reasons. As a employee, it puts the I-140 in your hands rather than the employer's. But also because of some of the expanded criteria, it offers opportunities for folks to file NIW where that wasn't the case before some of these memos and White House policy came out. So there's certainly more applicants from those categories, but I'll have Charlie speak on how that impacts the numbers and the Visa Bulletin for progression.
Yeah. I see no reason to believe that rest of world second or third will be current again in the foreseeable future. So I would expect rest of world EB2 and 3 final action dates throughout the remainder of fiscal 2024, and most likely for a considerable amount, if not all, of fiscal 2025.
Okay. So do you anticipate Philippines EB2 and EB3 dates to remain consistent with the rest of the world throughout this fiscal year?
I think that the Philippines employment second preference will remain at the worldwide date. The demand level there compared to the per country limit has never been excessive. I do believe there's an excellent chance that Philippines third preference the final action date will fall behind that of rest of world. So there would be a separate earlier date listed for Philippines employment third preference by the end of the fiscal year.
Okay.
Hopefully that will not be the case, but I think that increasing levels of Philippines third preference demand may result in that.
Okay. We go to the next slide. We have more questions. What will the future movement of EB2, EB3 India, and is it going to touch 2013? We talked about that as well.
Yeah, I don't see any possibility of either of those preferences reaching a 2013 final action date during fiscal 2024.
And then would F2A final action date reach July 2022 by the end of fiscal year 2024?
I don't think so. The July of 22, yes, I think that will be reached probably in the summer months. I was misreading that. I was thinking the priority date was a 2024 date. But yes, I think a F2A, other than Mexico, I think there's an excellent chance that a July 22nd date will be reached probably sometime in the summer months.
So right now it's in February
of 2020.
So you're predicting it could go up to July 2022?
I think that there is a chance. And like I said, that the category was current for so long. So, therefore, many of the applicants who had early priority dates, in theory, should have been processed long ago. And so the State Department may be slowly advancing that just to make sure that there is not unknown demand out there, or maybe they do have found demand that they didn't know about in the future. But again, I would think that the July 22nd date should be reached at sometime in the summer, maybe late in the summer.
But then if the petitioners become U.S. citizens, right, then they go into immediate relative, so that more numbers available, right?
Right. And that's, so that's another issue that could result in more numbers becoming available.
Okay, so hopefully good news there. Would you explore possible rationale behind the 7% country cap? What is the biggest concern in removing it altogether?
Yeah, when the Immigration Act of 1990 was passed and it took effect in fiscal 1992, they imposed the 7% per country limit cap in an effort to prevent a few countries from monopolizing the vast majority of the numbers. And when, in terms of what are the concerns with removing it, if there were no employment per country limit, then Indian applicants would use the vast majority of the numbers available in the first, second, and third preference, followed by China and the Philippines. So you would have maybe 3 to 5 countries using virtually all of the employment numbers, and nobody else really getting any. On the family side, both Mexico and Philippines could use the vast majority of the family-sponsored numbers if there were no 7% country cap.
And then to change that 7% country cap,
that would be the legislative, because that is in the Immigration and Nationality Act, so it is legal.
Okay. And then Laura, this one's for you. Status change to case remain pending due to prior date not current. Do they, I think meaning USCIS, check every month the previous pending cases? So what is your comment to that?
They should, although practically, we don't know how they manage that. So I think if you're in this situation, reach out to your immigration attorney or have, submit an Ask Emma ticket. We find success when we ping the file through service requests or through the Ask Emma. So it's not clear how USCIS sort of shifts it into that final action state, but obviously working with your attorney to make sure you have a strategy in place to ensure it doesn't just sit on an officer's desk, so to speak.
Yeah, but it usually, the response, usually it's going to take us 30 to 60 days to look at your case. So you're hoping that the prior date will continue to remain current. Right?
Well, and I
Right.
can tell you that one of the goals of Immigration Service using the application filing dates, in theory, if I filed my case, months ago, they would have been processing it in the interim. And even though my priority date was not eligible, once they had done all the required processing, they would request a visa number from the visa office. And they get one of two responses. If my priority date is within the applicable final action date, then a response is back saying the visa authorization was granted. They can print that off and stick it in my case file, and I would get a green card. And when that's processed, if they submit the request and my priority date is not within the current final action date, then the State Department would hold that request. And whenever, say in March, if the final action date advanced sufficiently, then they would send an email message to this USCIS requesting office saying, Charlie Oppenheim's case number A123 has been authorized for the month of March. They print that off and they could, ship it off to get a green card processed. So there is a system in place, assuming that the processing is taking place and numbers are being requested.
So basically, Charlie, what you're saying is that the USCIS will request a number from Department of State. Department of State says, no, sorry, no number. But then you put it like on a wait list, waiting. And then Department of State actually pings USCIS and says, hey, your number's available now. So there's actually a trigger coming from Department of State as well.
Yes, it's coming from state, and it's the goal of using the application filing dates, because then the State Department, when they're determining the dates, they can say, they would count, I would be one number against whatever the target they wanted, and they'd know. So again, it's assuming that they're processing all the cases and they're reporting them to the State Department.
And the State Department, once you know the numbers, you immediately notify the USCIS. So they have as long as the date's current for those next 30 days, they can then issue the green card.
Yeah. Well, once they make the authorization, it doesn't matter, because my case was eligible in the month of March. They authorized a visa number effective March. If it takes them till July to actually, get my green card process, it doesn't matter that their date retrogressed in April or May or June. The key is that it was available and an authorization was made.
Wow, I didn't know that. So once Department of State issues the authorization, even if it takes the USCIS a bit of time to finish up their adjudication.
Well, like I said, in theory, all processing, any required interview, all security clearances, etc., all that has been done before they make the request for a visa number to the State Department. So the only thing that they may have to do is if there had been a significant amount of time, they may have to run a new security clearance on it. But otherwise, if there weren't any time-sensitive documents that they had to be concerned with, they got the email from the State Department, and on March 1st, they could start, send it off to the green card facility.
Right. Thanks for that background information. We can go to the next slide. Does Charlie predict dates of filing Chart B to move this March, or would final action gap have to get closer first?
For the Chart B dates, I don't think they'll move them until they determine that their estimates for the current dates are insufficient to allow the annual limits to be reached. If that were the case, then they would advance them to generate more demand. Or, as I said, there in some instances, particularly in the family-sponsored categories, in the summer months, they would advance them again in order to start generating demand, which could be processed, starting in October of the next fiscal year.
So to be clear, Charlie, this is a question that's relevant. You're saying that for Chart B, for filing, that it could be paused for the next couple of months, aligning with the end of Q2, like that they're going to sort of hold the dates for filing.
Yeah, in theory, when the dates are established and announced in the October Visa Bulletin in Chart B, that is really where they think that things will be in September. And the reason being is they want to allow for USCIS, the cases are filed in October and November. They can start working on those cases and, like I said, submit them to, once they finalize action on them, submit them to the State Department so they can be processed later in the fiscal year. The only reason they would move it if they estimated that the Chart B date that they announced in October would generate, say, 10,000 petitions being filed. If they only got 5, then they would say, oh, we got to move it to generate the other 5. But in most cases, they've made estimates that are pretty accurate that would allow them to get the 10 that they expected.
Makes sense.
I guess repeat question. Possible movements of the Visa Bulletin on final date and final action date for March 2024.
Yeah, we listed those projected movements. I think that they're, potentially could be in March, but we'll have to wait and see. Again, if my theory about that they're doing things for the quarter, it may be until the April dates, but I would expect them. I think that date movement may become more regular in April and beyond because, they may have been holding things for the first 2 quarters. We're starting in October and January in an effort to gauge what what is happening, but they can't. They're unlikely to continue doing that and set the dates for April for what they think the next 3 months are going to be, because going into the summer, they don't have as much time to recover if their estimates were incorrect and they need more numbers.
Okay, and then usually do you see a slowdown in the summer months of visa appointment scheduling or any change seasonally?
Definitely, because if the quarterly limits are used, then there are only 19% of the numbers available for use July through September. Also, when I was doing the dates, my goal was to use the vast majority of the numbers through May, if at all possible, so maybe linger into June a little bit, especially on the family side, because I never wanted to go into the summer months where there were large amounts of numbers which remain needing to be used. And for overseas posts, there's the transfer season for a lot of the foreign service staff. There may be staffing gaps. They may need to devote immigrant staff to be processing non-immigrant visas, which that workload increases. And again, it's easier to kind of let your foot off the gas and kind of coast into the end of the year than having to be slamming on it and flooring it, for those final months and hoping that you're going to hit the limit. But again, there can be movement in a category such as India second or third, where you already have plenty of demand. And often I would work with the service centers, and they would ask me for projections of where I thought the September date was going to be. And they would, any cases they had to reevaluate, they would go ahead and do it, knowing that I was going to move the dates at some point once I had, knew that I had extra numbers to use. So.
Okay. And then Laura, this one's for you. How will the $25 million Apple settlement with the DOJ regarding perm recruitment change perm recruitment in the future? I'm sure you're getting a lot of questions about that.
Yeah, this is something we're meeting with clients about to update their perm recruitments, advise them of the settlement, and essentially the biggest change for many companies we're advising is to post recruitment on their website. So the whole sort of intent behind the pushback from Department of Justice about perm recruitment is sort of the fair treatment for U.S. workers and aligning the perm recruitment with the normal hiring process. So if you're managing a perm program where your perm recruitment looks vastly different, meaning the way you're handling applications, how you're reviewing applications different from your normal hiring practices, you're going to want to meet with your immigration counsel to ask some questions about what steps you can take. There might be resourcing challenges and flagging which applicants are for which, but we need to start taking those steps in that direction because that's what these lawsuits are effectively pointing. Now, it is challenging because perm recruitment does require some differences like posting in a newspaper. I know many clients don't do that for their normal hiring requirements. So that, of course, there are some differences that you need to comply with for the perm recruitment, but to the best of your company's ability and things that are in your control, like how you're receiving resumes, looking at your program about how you do that for normal hiring practices and looking to align the perm program in that direction.
Thanks. Yeah, it's a tough thing to go through with your client, So we can go through some of the live questions we received. So Charlie, this is for you. In a pool of total documentarily qualified applicants in the family preference categories, how much of them typically are F2A applicants in a given month? In other words, does F2A constitute more than 50% or less than 50% of the total documentarily qualified applicants in family preference categories?
It's hard to say in terms of the demand, but the 2A category gets approximately 50% of the overall family limit. So they are getting lion's share. The other preferences get the limits are 23,400 for first and third preference, 65,000 for fourth preference, and 114,200 for F2A and F2B use. So F2A gets the bulk of the numbers, and F2A gets 77% of the 114,000 numbers.
Okay. Some people have started forecasting the filing and final action for next fiscal year based on recently released data of USCIS. How far do you see the filing date to move in the next fiscal year?
I would not hazard a guess at this point. I think because it depends heavily on how many numbers can be used this year. As I said, if China gets lucky and there is lots of fall down of unused family-sponsored numbers, then you may be able to take a bigger chunk out of the pending China demand that would otherwise need to be processed in fiscal 2025. And the same for potentially for India. You're also going to have new filings in the meantime. You also may have people that are deciding, particularly in India, there could be Indian second preference applicants who decide to downgrade to India third, or India third preference that end up upgrading to India second. So all those there's so many variables that need to be taken into consideration. I think it's way too early to hazard any real guess of what will happen with the dates in fiscal 2025. Other than, as I said, I expect the rest of world employment second and third to continue having final action dates in 2025.
Yeah, so I don't know, Laura, if you're seeing this too, but I'm seeing some requests to change lanes again, right, to downgrade. And then the company had already done it before, so the company's actually revisiting their policy on how many lane changes they'll permit and support. So that's really coming to light now after all these, movement in the Visa Bulletin and EB3 becoming a little bit faster than EB2. Are you seeing the same?
Yeah, and in fact, I had a client whose who was ready to file EB2 last month, but I said, why don't we wait to see if your EB3 date becomes current for February? And it did, and now we're going to just concurrently file final action under EB3, and that preserve the company's resources so that they're not having to do that upgrade downgraded. Admittedly, this employee was patient and, wanted sort of to see it play out. Some clients are really anxious, understandably, wanting to get something just on file where this employee will benefit from filing with final action. So, so kudos to this employee hanging with us.
Yeah, another important thing to remember is the employment annual limit for 2025 is likely to be at least 10,000 less than it is in the current year. So where we're facing lower per country limits this in fiscal 2024, the situation is likely to get worse in 2025.
Yeah. So Charlie, this kind of goes back to the question I had asked you. So this individual said, my priority date, November 10, 2022, both final action date and date for filing were current in November 2022 for EB2 and IW rest of world. Becomes current in February 2024, according to the February Visa Bulletin that was recently issued on January 10, 2024. Weirdly enough, my I-485 case was approved on the same day the February Visa Bulletin came out, even though my priority date won't be current until February 1, 2024, about 21 days later. Was my I-485 approval a mistake, and should the USCIS be informed?
No.
That's good news. No, it wasn't.
It's good news. And I'll give you an example. Say that your priority date becomes available for the month of February, but the Immigration Service had pre-adjudicated it and submitted it to the State Department. When the State Department determined the February dates on, say, January 8th, they would have sent, when they did it's called an allocation run, when they did that on January 8th, they would have sent an email message to the Immigration Service saying that the case is eligible. Here's the authorization, but it's eligible effective February 1st. So immigration would have gotten the email on January 8th, and they could take action on February 1st.
So they could have approved the 485 in January, even though...
Sure. If say that the applicant submitted all the required paperwork months ago, all the requested information, like I said, the Immigration Service, in theory, once the case is filed based on the application or final action dates, they're processing that case, and they will fully process it and then submit the request to the visa office, where they get one of two responses. It's immediately approved, or it will get a response saying it's gone into the pending demand file, which obviously this person's did, but it became eligible based on the newly announced dates, and therefore Immigration Service got the authorization.
So as long as the following month's Visa Bulletin shows that your priority date is current, the USCIS can still approve it for the prior month, right? As long as a Visa Bulletin has already been issued, right? Because in this case, it was issued on January 10, 2024, 485 approved on January 10, 2024. The Visa Bulletin shows his number would be current on February 1, 2024.
Right. Immigration cannot send his case off to get a green card produced. They cannot actually adjust the status till February 1st, even though they got the notice in January.
Okay, so the effective date of his green card should be February 1.
February 1st.
Okay.
Yeah.
Okay,
and there would be literally thousands of those notices going out to the Immigration Service.
Okay, so for this person who asked a question, just check to make sure your green card states issuance date February 1, 2024. Is that what you're saying?
Yeah, and this is standard. This is nothing new. This has been going on, definitely since they started using the application dates in 2015. But even before that, they would have, if a case was subject to a retrogression, but they had accepted it earlier, they should have gone ahead and completed action on the case and requested a visa number.
Okay. Well, we're at time. So thank you, Charlie and Laura. And again, we are going to move to a different platform starting next month. You'll get an email if you regularly subscribe to our Chatting with Charlies. And with that, thank you, Charlie and Laura, for joining me again today.
Thanks, Charina.
Take care.
See you next month.
Bye.